So what is trademark infringement? A trademark by its very nature makes the public aware. It uses some mark to represent a business, a product, a service, a brand. And so that customers in the market can recognize the source of goods or services being provided. On a trademark in some way creates customer confusion as to the origin of that good service brand, etc. That is, it causes some level of misunderstanding by the customer as to what company or what brand or what product or service it is, who is manufacturing it, who is providing the service, etc. Okay, so that's the key element that you're looking for there. You look for similarities in the mark, you look for similarities across industries, across product classes. So if the mark itself is extremely similar, and they're in the same industry or it's the same type of product as the alleged infringing product, it's more likely that infringement has resulted. But if it's a similar mark but not exact, and it's in a different industry completely, generally this is not going to be a direct or literal infringement. Now, there is an exception to this. There's a doctrine called dilution that the court will recognize, and there are several elements to this claim, but basically what it says is that a famous mark that is one that has exceptional notoriety is something similar, very similar to it, is being used in commerce by another company, brand, product, or service. Okay. And it is causing in the market association between this other product, service, brand, business, etc., and the trademark holder. That is, customers again are being confused about whether these products, services, brands are associated because the trademark is so similar in nature and is starting to associate these goods from different industries. Okay, so in this situation where you got a similar mark, goods in different industries even that are completely unrelated can have a negative effect on the trademark holder. And if they can show that this level of association between these non-related products, between these non-related brands or businesses is causing some level of dilution of the distinctiveness of the original trademark holder, it's somehow harming their reputation, such as associating inferior quality goods or something like that with the trademark holder, then they can seek a cease and desist order and stop this third party from using that mark associated with these other goods, services, brands, businesses, etc.